We're still on social media platforms and their Gulf context. And this is the penultimate session. And just after lunch.
The audience after the meal. So وعنوان محورنا
So our topic today is social media between legal framework and regulatory surveillance. So it includes two topics, legal framework and regulatory surveillance. Most Gulf countries have some kind of a legal framework to deal with this modern space. I will not take too long. We have Mr. and Dr. Bilal Sandid has a PhD in law from Montpellier in France and Lebanese University. He is a member of the Council on Governance and an advisor for public and private institutions such as the Kuwait Chamber of Commerce and Industry. He is a professor in Kuwait University, a researcher who has published many legal studies and constitutional studies. He writes a column in the Al Jarida newspaper. He focuses on sustainable development, self-development, politics, economy, digital transformations. The floor is yours. You will have 15 minutes and we'll set the timer. Good afternoon. Thank you for the Arab Center for having me and for this afternoon session after a heavy lunch. I will try to speak in light terms, even though it is quite a dense topic. And I will start with a confession that this is not an easy topic since we're talking about the freedom of expression. There are always different points of view. Freedom of expression has been a complex issue for decades, and there are perspectives from the opposition, the authority, and the people. So if we focus on this title, we can find in each of these titles a problem. Freedom of expression. This is an international problem right now. Digital spaces have intensified that problem. There is the problem of Trump with the X platform, and Dr. Tariq from Algeria told me about that in Australia. They banned Facebook for people under the age of 16. Is this a freedom of expression? Is this oppression? Is this regulation? Also, the general system. This is a legal term that we will talk about. The legal order is something basic in laws. The public order is different because it's related to behaviors, public decency, and so on and so forth. So a study in the Kuwaiti comparative law, because Kuwait is not a new specific case, but because I live there, I tried to take some examples from their laws for practicality's sake. And again, we have a technical issue here. I might summarize my presentation with this slide. And I know in scientific conferences we cannot say everything in 20 minutes. So my first slide, I tried to summarize everything. So from the cry of an infant to digital expression. And I chose this title because All of what I want to say is that dealing with the freedom of expression, especially digitally, needs to be with the instinct of a human being. The instinct is built or is based on balance. The cry of an infant expresses a need of hunger or pain. And those who fulfill that need are the people with authority, people with the decision, the mother. So, when we have two cases, an infant who is always crying, always complaining, his mother becomes confused. She doesn't know if he's hungry or if he is just grumpy in general. And if the mother leaves the baby, even though he is crying, he might cry from his pain. So, with this simple equation, we might look at the history of the freedom of expression. And I can't see the slide on my screen. If one of the technicians can help me. So, since the first instinct and then as a right from authorities, international right, and then an international recognized right. So the main problem statement is related to four main questions. The digital space has become influential in shaping collective consciousness. Everything that we see on Facebook, including politics, social behavior, also the legal framework, as my colleague said, is regulation and surveillance oversight, and it entails sanctions as well, or penalties. What we require, from my point of view, is to strike a balance between the freedom of expression, security interests, and interests of the community stability under the public order, and we might go into details of that. So we start with the first pillar, which is the freedom of opinion and freedom of expression. Perhaps for non-experts, they do not distinguish between the two terms, but in Article 19 in the Universal Declaration of Human Rights distinguishes between both, and the UN considers them the cornerstone for any democratic society. The freedom of opinion is a human's ability to have their own beliefs and convictions, and the freedom of expression is having effective tools to disclose these opinions and exchange them. So we do not oppress people's freedom to have opinion and to practice those opinions and beliefs. We always say that the law is a reflection of what is desired by communities. So the international law and the local law has documented the freedom of expression and freedom of opinion. For example, the International Convention on Civil Rights, European and international conventions, and the constitutions such as the Kuwaiti Constitution, Articles 36 and 37, and other laws such as the Kuwaiti commitments to international agreements, and some laws and regulations to protect the public order. What are the criteria for the application of restrictions for freedom of expression? This slide is very accurate or very critical. First, the law should not violate legitimacy and clarity, meaning clear regulations that are well organized. So this shouldn't be something that is not well known to people or not published in the Gazette. So it should be simple, published in the newspaper, official newspaper, to go into effect. We cannot enforce a law that was not published in the newspaper, and the penal code should not be too loose or subject for interpretation that gives the authorities the opportunity to penalize anyone who expresses any idea that is deemed by the judge and authorities as something that is not beneficial. The goal here is to protect the public interest, and we shouldn't violate that under many legal considerations, such as violating authorities or misuse of authorities, proportionality, which means that the penalty should be proportional to the action. And there are many examples around the world. There is the European Court of Human Rights in Delphi and Estonia case. They found that one of the tweets indeed assaults or abuses some of the companies, but they found that the penalty is no more than a fee. So there is restriction on your freedom of expression, but there is proportionality in the penalties imposed as a result. So why does the freedom of expression why does it take different dimensions in digital transformation? Because it has features helping freedom of expression and universality and distribution around the world. 70% of the world's population use digital means of expression. How and why? That's not necessary to know, but it's a daily type of use. Also, the availability. It's accessible to most people. Multipolarity. We have so many parties and groups, men, women, intellects. It's interactive and not central. So the freedom of expression in this digital space, as was said by a judge in the Supreme Court in the USA, has transitioned the freedom of expression from these courts to the digital spheres, and it has become a fifth authority. We used to say that journalism is the fourth authority, and now we can say that it is the fourth estate. And so this pillar, this is the second pillar before we get to the conclusions on the legal framework for the freedom of expression, based on the international law, UN conventions and agreements, and the UN vision, and local constitutions, and taking examples from Kuwait, 4 main laws related to freedom of expression: cyber law, cybercrime law, publications law, electronic media law, and audiovisual content law. So it is hard to present all of these laws, but these are just examples from their articles. Article 14 of the cybercrime law it criminalizes any threatening or extortion of a person to deter that. So we shouldn't understand freedom of expression as something that is related to oppression and negativity. No, it is a protection for the community. And so restrictions, even in the social contract, this is also for those who are not specialized. This idea is that anyone who would relinquish their basic rights to in favor of the state that has the authority and protects the community using these regulations. Also, public indecency, human trafficking, trafficking drugs, and financing terrorism. There are many other legal points And there is also the control, administrative control, which is something that is preventive and then immediate, and then something that comes later or afterward. It's something that is done within the threshold of the law to prevent before or during or after the post or tweet, to take some measures where restrictions are practiced within the limitations of the law. There are many examples, starting with licensing to the digital platforms nowadays. When you open a digital, can you open or start a digital newspaper without a license? No, you need a license. This is a kind of a control, also following up on everything that is published, and also taking or imposing some penalties as a result. 4 minutes only. So how did the Kuwaiti judiciary deal with these things? There are principles, fixed principles that do not only apply to digital freedom of expression, it applies to judiciary dealing with all freedom of expression, and they are principles. They might be perceived as control of the judiciary. First, the general approach is that judiciary judges are humans who are influenced by their surrounding environment. So they look at things in a more comprehensive vision. For example, if the same tweet today, if it's said at a certain time, it could be accepted and not to be considered an attack on the security of the state. On another day, on another time, it could be an attack. In another time, let's take a practical example. For example, today I have a tweet, I support Israel. In one of the Arab countries, you might be held accountable, but after normalization, it could just be liked. So it's relative. And this is not something that legal people like. In laws, we like things to be strict. So the main outcomes or findings, I believe the freedom of expression, digital freedom of expression, made freedom of expression more vulnerable. Yes, it opened many horizons and doors, expanded the horizons of expression, but it made it more vulnerable. We all became political analysts, media representatives. We all post on Facebook, Twitter, and the various platforms, whatever we want. So it made this freedom of expression more vulnerable and created more confusion around the world in dealing with this freedom of expression. As I said, all countries are confused on how to approach this trans-border space. There's difficulty in identifying the legitimacy, the principle of legitimacy. The Kuwaiti legal system balanced between control and deterrence using penalties, but in the recommendations, I say that it needs to be updated and standardize its terminology. And my personal conviction is that we should always go back to our instinct and strike a balance and have gradual penalties in dealing with digital freedom of expressions. I will not mention the recommendations because we don't have enough time. We will discuss them during the questions later. Thank you very much.
We thank Doctor for his presentation and the valuable information he offered. Now we give the floor to Dr. Ahmed Badran and Sarah Badran to quickly introduce him. Sarah is a PhD candidate at Cambridge University. She got her MA in digital humanities, and she is a member of the Governance and the Human Rights Center. She worked on different projects to do with logarithms and biases. She has published in peer-reviewed journals on AI and higher education. I gave them 10 minutes each, 20 minutes in total for both of them.
Her presentation in English, okay? Thank you.
Okay. How do I? Okay. Assalamu alaikum, thank you. As Dr. has explained, I will be doing my section in English, but Dr. Badran will be doing his section in Arabic. So our paper is titled, Should Social Media Come Under Regulatory Purview? Ethical Considerations of Influencer Marketing in the GCC Region. So just to outline our study, I will firstly contextualise our thought process, then we will conceptualise some key concepts like social media, what a social media influencer actually is, who's being influenced, what are they influenced by, and then we'll shift on to some key concepts like transparency, honesty, privacy, algorithmic personalisation, and then that brings us to the gaps in current regulatory frameworks and the call for new or updated regulations and the current hindering factors, as well as the research questions for our study specifically, our chosen methodology, and a GCC-specific region breakdown of current policy frameworks and future suggestions. So in terms of contextualizing the studies, we have witnessed a boom in social media platforms, and marketing strategies have also shifted worldwide, where we place these central actors who we consider influencers and social media influencers to try and sell products and services, which can create a lot of conflicts as not all products and services are equal. And we've had previous discussions over the last couple of days about services which can be problematic when advertised on social media, such as maid services, and then we have products marketed towards the general public. And we also have political actors which are very active on social media and propel their agenda using these tools. So this is really specific to the GCC region in particular, as it experiences one of the highest social media usages globally. And it has a very unique cultural and social context where the nationals, expats and tourist experiences are all enmeshed together. Which reflects that existing regulatory frameworks and bodies are not necessarily transferable to the GCC region or would work effectively in the GCC region. So we've identified three main concerns which have guided this study, being transparency, credibility, and consumer protection. So we've spoken about social media quite a lot over the last couple of days, and it's actually important to define instead of overgeneralizing or assuming a universal understanding of what falls under this growing umbrella of social media. There are characteristics which are specific to social media that we do not have in other digital medias, like emails, for example, which need to be defined so they can be expressed accurately and can be considered within the bracket of regulation effectively. So definitions either tend to converge around the notion of user-generated content and/or interaction, or focusing on channel characteristics. So we choose to adopt the following definition from Obar and Wildman, which states that social media are internet-based, disentrained and persistent channels of mass personal communication, facilitating perceptions of interactions among users, deriving value from user-generated content. The fact that it derives value from user-generated content is key to our study, where social media influencers, companies, users, they all begin to converge, and these lines between who is creating and consuming the content increasingly begin to become blurred especially when political actors and state actors are also using and adopting these tools to forward their motivations and not always explicitly stating boundaries between opinion and fact and political motivation. So when we think about social media influencers, we need to think who is doing the influence, who are they influenced by, and who are they influencing in turn. So a lot of definitions we found in the literature discuss endorsement of a product or services and pursuit of business goals. So it becomes very clear that these lines can increasingly become blurred. It's not always clear, and in the same way that not all content is equal, not all producers of content are equal, and when we are talking about regulation, we can't disconnect the technology from the political, social and cultural sphere in which it operates, and the digital public sphere in which it impacts. So by assuming there's some type of universal or generalizable set of regulatory frameworks or a singular regulatory body is an overgeneralization or oversimplification of the topic, and the people who are being affected also needs to be considered. Not all users are equal. For example, we have more vulnerable users such as children. As Dr. mentioned, that Australia has banned social media for under 16-year-olds as of last week. So countries all around the globe are increasingly taking steps forward in trying to navigate the complexities of how social media is being used and adopted, and the actual role and impact of all of these influential figures who we kind of throw under this bracket of just being social media influencers or content creators. So it brings us to the question of how does one influence per se? So there are four main business models that can be identified. We have affiliate marketing, which pays money for users based on clicks, exchange of goods or services, often in the form of a post, review, story. You see this a lot of influencers, for example, at restaurants or on various holidays. You also get compensation for framework contracting, and this is the one that starts to become a bit more tricky when the influencer becomes a producer or a provider. This takes the form of collaboration and merchandise. Again, these four models don't necessarily happen in isolation. A lot of times, contract deals ask influencers to do one or more of these. So again, the boundaries between what is happening, how they're compensated, and how it's presented to the user is not always distinct or clear. So this brings us to some key questions where we're considering who's being influenced and the processes which are also influencing them. So now the majority of profiles and brands and companies and political parties and NGOs are very present on all sorts of social media, which emphasizes the fact, again, that one generalizable framework is insufficient, as well as the consideration of children, which are increasingly becoming immersed and surrounded by these technologies and are growing up very much enmeshed in this digital sphere. And we need to consider that the voices that make our way onto these screens, this is no mere coincidence. There are decision process and exclusionary processes which are happening algorithmically behind the scenes and region specific, which mean that certain voices and ideologies are propelled while some are intentionally silenced. So we cannot consider this merely a technological issue and attempting to disconnect the technology from the political sphere in which it operates is a very reductive approach. So it brings us on to some ideas. We'll go over transparency, honesty, privacy, and algorithmic personalization. So to start with transparency and honesty, there's an idea of brand reputation, customer loyalty, trust, and utilizing existing fan bases to buy advertised products and services, which also has increasingly invited ethical considerations such as the need to disclose paid partnerships, which have not always been the case, and it blurs the boundaries between opinion and advertisement. So there are consumer protection laws around the world where the the consumer and the user remains central to these practices, such as the US, EU, UK. We also have various data protection laws in the UK, like GDPR. But this does need further development in other countries, and the GCC over the last few years is beginning to adopt some of these frameworks and policies, borrowing ideas from various other institutions whilst also making region and specific considerations. So in terms of algorithmic personalization, the development and boost of algorithms and the entrenchment of these processes and algorithms into our social media networks and our social media platforms has provided brands with the advantage of being able to engage with target audiences more specifically. But from a user perspective, there are also various ethical concerns regarding privacy, transparency, and there is a gap in understanding the reuse and repackaging of our data that is collected through social media platforms, and also that is used and repackaged based on what we upload and what we engage with online. So many scholars have argued for the insufficiency of end-user licensing by using social media kind of fill that gap that we currently have. Without this understanding, it can lead to many issues like behaviour augmentation, where our digital selves are ascribed data and they are ascribed expectations which then reflect onto our personal selves, and there's this tension between the two notions: manipulation into product purchase through aggressive marketing, and like we said, the legal frameworks about end-user license agreements also need to be updated and reconsidered. I will now pass it over to Dr. Badran, which will talk more about the specific regulatory frameworks that we're suggesting and region-specific examples across the GCC. Thank you.
Thank you, Sarah. الآن دكتور
Dr. Ahmed Badran is an associate professor and he's the head of department at the Faculty of Arts in Qatar University formerly. He got his PhD from Exeter University. He has wide-ranging expert. And Dr. Ahmed Badran will continue under the same title, and that is, should the social media outlets be regulated through in the GCC area? We will give you 10 minutes. Thank you very much, Dr. Fahad. Assalamu alaikum. Please, I will speak in Arabic because the majority are Arabic speakers. Before I build on what Sarah has said, I want to shed light on the phenomena we're dealing with. It's rather complicated. It has dimensions to do with the technical aspects or the ethical considerations, legal considerations. This was one of the challenges we faced when we started working on this paper, and that is to determine what do we want to study accurately regarding social media. As you know, the applications are many. I will not repeat what colleagues have been talking about over the last 2 days, that whether we like it or not, we live in an era which these social media tools can come to us whether we like it or not, and some say it's like water and air. We cannot live freely on, and we do it almost spontaneously. We wanted to be more specific. We asked in the social media, what should we study? And we wanted to focus on the role of the influencers who want to market their goods or services through social media platforms. So our analysis focused primarily on the influencers, especially those who offer content which has an advertising side to it. This is a rhetoric question. I'm I'm impersonating Shakespeare and saying to regulate or not to regulate. This is the question. And Dr. Bilal said this has been determined already because of the huge impact social media has on our lives. So therefore, regulation becomes inevitable and it's a necessity. For this reason, many countries have taken steps to come up with regulatory frameworks and on what is being published through social media and to make sure that the content will not be harmful to the users. But in my opinion, the most important question is how to regulate. This is not a traditional economic activity that we can deal with it. I studied regulation since 2005. My basic specialty is regulatory governance, but social media, in the fluidity it has or the flexibility it has, not necessarily subject to the traditional ways of regulation. So therefore, we want to use new entry points. For example, some platforms through which this content is broadcast, there is a margin of profit which is very big, which makes them not necessarily comply with the regulatory frameworks because by and large they want to make profit, and this can be a motive for them to have a creative compliance that on the face of it they keep in line with the regulatory rules, but in actual fact they find ways and means to increase their revenues. Sarah spoke about confidence building. This is very important, and a large part of the influencers' work is based on the trust people have in them. This is a very important factor. If the government interferes to regulate the activity of these influencers and the followers started reacting with their followers, here some kind of lack of trust can be created. And the regulatory frame can be presented as curtailing the freedom and the ability of these influencers to work. So this is very sensitive, very important. Trust here is a relationship, and relationship has to be established over a long period of time and interaction. When you deal with the person for the first time, you do not have trust in them, but after a history of dealing, trust can be built. I will not repeat what Sarah talked about so far as transparency is concerned, or data privacy and privacy. All of these things raise important questions in an environment like this when all the borders between the regulator and the regulatee, between the content maker, producer, content user, regulation becomes very murky as a concept, very vague. How can a state can interfere and regulate this? Of course, in a way we can maximize the benefits, but at the same time we make sure that the safety of the users is also guaranteed. So therefore we focused GCC countries and the regulatory frameworks, and we we analyze the content and the legislation which regulate media, and especially the social media tools, without delving into details. The details of this analysis is available in the paper itself, but in the time allocated to us, we will try to talk about the main denominators that we have concluded in the GCC countries, and we may go back to some details in the Q&A sessions if there is any need to elaborate in specific cases. The common denominators, there is agreement in all GCC countries that this sector needs to be regulated one way or another through tools which are similar to each other in different GCC countries, whether to do with regulating the media in general or things to do with privacy and data collection, which is related to social media and content creating. But generally speaking, the regulatory tools, that legislation was one of the main tools. Some legislations can automatically apply to social media and the content which is being produced and marketed through the social media. Some countries wanted to go a step further and to have a framework specific to social media, and that is to do with licensing. Most countries either legislated a framework for licensing, which requires these influencers or marketers to have a license before producing or broadcasting any content through social media, and they're also governed by very clear standards regarding the content which is being produced and broadcast through the social media. So therefore there is similarity in using legislation as regulatory tools and also to obtain licenses before embarking on any marketing campaigns through social media. Also, there is, in this context, there is some sort of censorship of the content. The GCC has its own peculiarity and particularity in the content, so therefore this content should not contradict the traditions of society. And finally, the part pertaining to protecting the consumer, which is very important because there are no legal agreements to protect those who produce and publish this content or those who consume it. So this 6 cases we took into consideration. What about the important issues? Number 1, and if we look at the case of the UAE and Saudi Arabia, is the case of the cost. When you get